Hi, my name is Natalia and I'm an attorney here in the state of Florida. And today I wanted to talk to you about estate planning. Estate planning is very important, not only because we are dealing with a global pandemic, but because you need to have a plan in place for when something happens to you. And this isn't just, when you pass away, but when you become incapacitated or when you are unavailable for other reasons, when you've been put under for just regular surgery, you need to have something in place. And so there's a couple of key aspects that I want to cover for things that you should be aware of, documents that you should be aware of that are part of the traditional estate planning goals. So number one is the healthcare surrogate living will. This is where you designate somebody and an alternative to take care of making those medical decisions for you when you can't. That means when you've lost your cognitive capacity, when you've been put under, for example, when there's just other reasons under which you can't be making your own decisions about what medical procedures you want done, what type of end of life care you want, what kind of intervention you want in the event of an emergency. All of those things are very important and they get put in to a living will. The other document I want to talk about is powers of attorney. So a power of attorney is a document that gets used while you are living, and it's not necessarily something that is essential if you've lost mental capacity. It can be used if you're perfectly fine, but you just don't have the time to go run all of your financial errands, and therein you're designating somebody and an alternative just in case to do all of those things for you. Talk to your bank, talk to Social Security, talk to the VA administration on your behalf, go deal with the DMV, a number of financial issues and matters that you want handled for you by somebody that you trust. It has no effect and it becomes useless upon your death. And unless it's got the proper language, it's also ineffective if you lose mental capacity. And then we have, of course, the last will and testaments or trusts. Sometimes trusts are used if people have multiple properties or they want to make sure that none of their heirs, beneficiaries, etc. have to deal with the probate court. But a last will and testament is generally a document in which you put in how you'd like your property to be distributed. You identify your beneficiaries at law. You identify your children, spouse, etc. And it provides the court with a guide of how you want your assets at the moment of your death to be administered. A trust is similar, but you've appointed a trustee to deal with that outside of the courtroom. Now, having a trust in place doesn't necessarily mean that no probate will be necessary. It depends, but it will minimize the likelihood of prolonged probate proceedings. One of the other types of documents that gets used frequently as part of an estate planning kind of role are called Ladybird Deeds. And that's when you deed your property over to maybe your children or somebody that you care about very much, and then you retain a life estate therein. So you keep it while you are living, you keep that interest, and then it jumps to them upon you passing away. Or deeds with joint tenancy and right of survivorship. So a deed in which, for example, you may add your adult children to title with you, and then upon your passing, it passes immediately to your children. But what you do have to be aware of is whomever you add to these deeds presently will have a present interest in the property. And if you decide to sell it, mortgage it, etc., you're going to have to get their consent as well. So those are some of the estate planning documents that you should be keeping in mind, and good luck out there.